So I think it's an important added a benefit of arbitration. But arbitration is a very broad church. I'm just conscious of the time, so I'm going to wrap up this and we'll hand over to you in a moment, Param. But so I'm talking principally what we understand is commercial arbitration, creatures of contract. There's a whole huge area, increasingly complex, that is really developed. When I started out, it was very much kind of like the esoteric world of academia. Nobody had anybody in-house specializing in investor-state arbitration. Now it's very much, you have boutique firms, entire firms, you have departments in it. It's really moved on. And of course, this is, as implied, involves states. So it's sexy stuff. It's big amounts of money. It's much more public because of the interest of transparency. But that's a whole area in itself. It has its own jurisprudence, but increasingly you see them overlapping. And it may well be that you have an investor-state case running in parallel with a contractual case if you're dealing with a state entity. So I just wanted to flag that down. India has had an interesting experience. They've been hit badly in the early 2000s with lots of, quite a few, more than its fair share of bilateral investment claims against it. And it shocked them to the roots, because I think they were finding that they were being hit for investments, change in tax regimes and things like that they never contemplated they would get hit for. They had a very wide, as was typical in most bilateral investment treaties, definition of investment. And they pushed back, and instead of throwing their toys out of the pram, what they did is then led the way, and they were world leaders in this, in creating the modern model types of bilateral investment treaties, where there's a far greater emphasis on clarifying exactly what the extent of those treaty protections are. So I just thought I'd throw that in, because, as I say, I think India's had a fundamental role in that evolution. And essentially, we have difference between administered arbitration, which is where an institution is involved. Inevitably, they're there to help administer, keep it running. They normally have their rules. There is a cost because there's an administration cost, but it's generally 2 or 3% of the overall cost. I personally think it's a cost worth having, because the alternative is to do it yourself, but you end up actually spending more time, unless number one, you need an equality of arms and everybody understand how it works. But generally speaking, it's much better if you've got an institution in hand. But obviously there's some cost, there may be some delay, and some of the service levels can be a bit patchy. But again, I've seen that increase significantly. I think so. That is all I would probably say about international arbitration, other than to conclude that it is actually, often you see a model clause is about 4 lines long, and you think, wow, this is really simple and easy to read. But we're into, we've got the whole thing up. Wow, great. We're into, I just thought I'd flag this about the applicable law, because there are so many angles to it. One is, does the party you are entering into arbitration, do they have the capacity? There are some, particularly with state entities, they may be prohibited from entering into arbitration agreements. So you need to look, and that might be one kind of law. The arbitration agreement itself is an agreement within an agreement. It sits within the main agreement. It may actually be in a separate document, but so long as it's clear that they are related. But that can be a completely different law. Generally, it's not. It's the same as the main contract, but it might be different. The arbitration proceedings themselves has its own regime, and this is what's known as the seat or place of arbitration, and that it's a legal term of art. So basically, that is what's going to police your arbitration. When things go wrong, you go to the court and say, can you help us out? Whether that's because you've got a intransigent or a witness that doesn't want to play ball, or something's gone wrong, you go to the court, and it doesn't really exist in a vacuum. Then there's the substantive issues themselves. The issues of that you will be determining may be a different law again. And then just to kind of round that up, is the place of enforcement you need to bear in mind. So there's a lot there to kind of assimilate, to get your head around and make sure you're covering when you are making, advising clients. And I think with that, and hopefully it's going to be a relatively smooth handover to Param. I think the important thing is, especially as the majority will be counsel, is knowing if you're going to, there's a difference between good counsel, excellent counsel. If you can be the media, hopefully everybody's aspiring to be at the top of their game. You need to be able to at least be aware of this, even if it's not you that's going to be the specialist, to engage with those in your prospective firms that will be the specialists in this area, so that the clients are aware that they have these options for them. And I think that is really important, that you, it's got to be right in terms of good practice. If you don't believe me on that, then just be careful. There's a stick there hanging over you. In most jurisdiction, there is a legal requirement to, ethically under your bar rules, and maybe a legal requirement to ensure that you put your client's interests first for yours. And that stick's not really used very much. I have known of a case, there aren't many, fortunately, in the UK, where a firm was sued because they didn't advise the client that they had the option of mediation. You kind of think, wow, that should make you think twice. That should make the compliance guys in firms think twice about that. So you should be putting it forward, even if you don't really believe in it, don't want to be doing it. I think there is a duty to be doing that. So I think it's really important to have this. And if you don't, and again, just in terms of the real world competitive, don't ever be the guy where you go to a client and you've been pitching, and then you say, well, that's all very well and good. And then they ask you, well, what? And you've not mentioned mediation, for example, because you've been concentrating on the big ticket arbitration. It does it makes you look a bit foolish, because it looks like you don't know your onions, as we would say in England. And worse still, it could make you look a bit shady, because it's like you know damn well it exists, but you chose not to because you're concentrating on the big number. The reality of it is these processes exist in parallel. It's not either or. Timing is very important. That's a strategic decision. But I think it's really important that you're aware that they exist. And clearly, if you're interested to get on board and really be familiar, because it's not litigation by another name. It's a specialist area, and hopefully we can explore a little bit more how you might get into that when Param starts talking about work opportunities. But before that, I think, Param, I'm going to hand over to you if you're going to talk us through mediation a bit, and then we'll see where the conversation takes us. But as I say, please ask if anything I've said that's not clear. We'll have an opportunity, I hope, at the end for questions as well. But do feel free, don't be shy to raise questions. Now, well, before I sit down, does anybody have any questions right here, right now? The arbitrator. Wow, that's well, you do your due diligence is the answer. I mean, at the end of the day, again, none of this is really rocket science. We all live and breathe by our reputation. If you are regarded as shady, the market will stay away from you. I think be careful, and I say this as a friend, and I always feel hesitant, but again, I think friends should be frank. Indian parties were it was a real problem to get them from appointing retired Supreme Court judges when you have three arbitrators as their arbitrator, because you can see the attraction. It's Indian, it's obviously high standing, and it's that sense, I've got a vote. Well, congratulate, all of that's good so far, but remember, there are 3 votes to get, and you can get the award on a majority. And I've seen all too often where the eminent Supreme Court judge has no idea, number one, what an arbitration is. I mean, really, he's never done one. Enjoying going on all the trips that they can, because so the costs are going up when it could have been done virtually, because they have no idea how to do all of that. I'm being provocative a little bit, but it's not just Indian judges. But there was a particular problem with Indian clients. But the real issue is, and this is why I was stressing about the majority point. Yeah, you've got a vote in the bag, but you lose. And what happens is, especially if the other arbitrators become switched on and think, oh, look, this guy either doesn't know what he's doing, and they don't, they play lip service, so it's all very courteous and very civil, but they won't engage with him. So he has zero influence on the chair. The chair is the key person in a 3-person. So that's not helpful. You want somebody who can engage robustly win the respect of the chair. So you want somebody who is there, and worst case scenario, if there's any whiff sense that they are compromised, worst case scenario, corrupted, I've seen that, but at least in bed with the appointing party, they will stay away, and that's wrong, because then you end up having like a tribunal within a tribunal. And that's very worrying. So the simple answer is you do your due diligence, you get people that you trust, even if they don't find in your favor. I mean, you obviously want people who's going to be sympathetic to your arguments, but you can't win them all. And it's important that that it is seen to be the arbitrator. You don't contaminate the arbitrator, but there's a potential challenge down the road, because they were seen not to be impartial or independent. But a really important one, and there's no dodging it. And one of the great things about it, and I would encourage you as you go through your careers, is to sit as arbitrators, because there's no substitute, I think, from then seeing these people in action for yourselves. And you'll be surprised. Some of the great and good are great and good for a reason. There are lots that pass their sell-by date, or perhaps were never really that great and good in the first place. But when you see them in action, and you don't have to wait to be an arbitrator to do it. One potential avenue for you guys might be getting a position as a secretary to a tribunal. And you're kind of the proverbial fly on the wall, assisting the administration. Of course, you're not involved in the decision itself, but that's a wonderful way of actually seeing an arbitration from start to finish, and also, importantly, seeing the deliberations that happen behind closed doors that you would never see as counsel. I'm sorry, I'm conscious of time. We'll come back to more questions, but thank you for yours. Param, do you want to? Oh, but shall I take it now, or? Absolutely.
Sir, arbitration is better in India, but globally, is it better or not?
Gosh, you're asking the tough question. India has had historically difficulty because you could never trust the courts. You would think you'd go through the process, and even though there were people who sincerely engaged with it, I've acted with a lot of Indian parties and council, very good. But there was a sense that you couldn't, they were very partial. That's changed considerably. It's definitely, the mood music has changed, and I think the direction of travel has changed. There is absolutely no reason at all why India cannot be a substantial arbitration hub in its own right. It's candidly bit late to the game. Everybody else has got arbitration centres going up left, right, and centre. Mumbai have made a great start, I think, visibly. With all due respect, I saw the Delhi centre here, which is fantastic. But I think in terms of visibility, Mumbai has definitely shown, and they are getting work in. So I think it's definitely, they are a player now. But what you're looking for with any place is consistency. And these things take time as well. You can't just say, wow, we just passed a fantastic act, everybody come here. It takes a time, and people need to be seen that you practice what you preach. So historically, there's a lot of work coming out of India. A lot of Indian parties, a lot of external investment from Indian parties all over the world. And I think what I've seen, I was commenting this, what I think is really interesting, I've got, just thinking of my current caseload, the number of Indians I have in front of me that are either of Indian descent, but a lot are Indian expats, and they are both sitting as arbitrators and counsel, and they're playing at the top table. And they're great, and that has changed dramatically over the years. So I think it's an exciting time. There's a lot to go, and you will be the future of all of that. And the wonderful thing is, it's obviously your own jurisdiction, but the world is your oyster, and it's a global business, and there's every opportunity for you to travel. There are obviously visa restrictions and what have you, but it's truly, in that sense, egalitarian. But the downside is you're competing not only with all your fellows sitting around here, but with the world. And there's it's a very competitive environment, but a very rewarding one, I think, if that's what you want to do. I don't know if I answered the question actually, but I tried. Do you mind? I'm happy to take more questions, but while you stew, and thank you for the two that have kind of got the conversation going, let me pass over to Param, because I think we need to talk about the media. Sorry, are you waving for a question?
So can there be justice without transparency in ADR?
Can there be justice without transparency?
Yes, sir. In ADR.
You mean how do you mean lack of, the fact that it's private between parties? I mean, you've got, when you say ADR, are you talking arbitration or mediation?
Sir, it's between mediation.
Well, that's an interesting question. It's particularly harder when you're dealing with state parties. I think yes, but there's a limit to the transparency where you can go, and I think that's one of the issues. The whole point about mediation, and I'm going to tread on your toes here, I'm sorry, is the fact that parties should be able to freely communicate, so that you don't want transparency. And this is why when you, on another level, because peace mediation, which we saw a disastrous example of, I'm not even, that wasn't peace mediation in the Oval Office the other day, that's another, I mean, again, it's a very broad church mediation, and you have to bear that in mind. But you should not be kind of giving running commentaries when people are negotiating. I don't think we're going to have much time for talking and negotiating, but mediating, because these things take time to incubate, and you need that degree of privacy. But certainly in terms of transparency, you do need transparency to dispel that sense of corruption which exists as well. And there is a tension and a difficulty there, but there are mechanisms where you can. So the straight answer to your question, yes, it can. And transparency is very important. There is a very important place for transparency, but at an appropriate time, and that needs to be managed. I mean, it's an obstacle, if you like, but it's manageable obstacle. And as for just to complete that, on arbitration, of course, there's no issue about that because it's between the parties. You don't need to tell the world what you've done. Param, I'm going to sit down because there'll be, sorry, sir. I think we'll come back for more questions. I just don't forget your question, but I think it's important we get the mediation side in because obviously that segues in. I think he wants to know about your mediation.
May I now request Professor Dr. Lalit Agarwal, sir, Vice President, MERI Group of Institutions, to present a token of appreciation and a gesture of gratitude to Mr. Joe Tirado.